Alvarado.
Mr. President, I rise today to speak in opposition.
The quorum call.
Thank you, Mr. President. I'd ask unanimous consent that the quorum call be vitiated.
Without objection.
Thank you, Mr. President. I rise today to speak in opposition to the proposed reauthorization of the expiring provisions of the Patriot Act incorporated in S. 1038. I have to say I find reauthorization especially troubling since we've waited until the last minute and are now being told that we must rush this bill through the Senate of the United States. There are a number of the Patriot Act provisions that are permanent, and they remain in place to give our intelligence community important tools to fight terrorism. But there are three controversial provisions that we're debating, commonly known as roving wiretap, lone wolf, and business records. And I have to tell you, at least from my point of view, and I think there are the senators here that agree with me, they're ripe for abuse, and they threaten Americans' constitutional freedoms. Now, as I start my remarks at the onset, I want to state that I firmly believe, as we all do, that terrorism is a serious threat to our great country, the United States, and we have to be focused like no other time in our history in seeking to protect our people, the American people. I sit on the Senate Armed Services Committee and the Senate Intelligence Committee. And on those two committees, much of my attention is centered on keeping Americans safe, both here and abroad. And I recognize that despite bin Laden's death, and we all celebrate because justice was delivered, we still live in a world where terrorism is a serious threat to our country, our economy, and to American lives. Our government does need the appropriate surveillance and anti-terrorism tools to achieve these important goals. And indeed, many of the Patriot Act's provisions, which I support, have made our nation safer since those devastating attacks on that day we'll always remember on 9/11. We know that for a fact. But the problem we confront today is that there are three provisions that we're debating that fail to strike the right balance between keeping us safe while protecting the privacy rights of Coloradans and all Americans. Instead, these three provisions are far too susceptible to abuse by the federal government, even in the name of keeping us safe from terrorism. I don't say this lightly, but my concerns about some of these provisions have only grown since I've been briefed on their interpretation and their implementation as a member of the Intelligence Committee. Let me share some examples. Currently, the intelligence community can place wide-ranging wiretaps on Americans without even identifying the target or the location of such surveillance. That's one concern. A second concern, the intelligence community can target individuals who have no connection to terrorist organizations. And a third concern that I have is they can collect business records on law-abiding Americans who have no connection to terrorism. We ought to be able to at least agree that the source of an investigation under the Patriot Act should have a terrorist-related focus. If we can't limit investigations to terrorism, my concern is, where do they end? Is there no amount of information that our government can collect that should be off limits? I know Coloradans are demanding that we at least place common sense limits on government investigations and link data collection to terrorist-related activities. If we pass this bill, Mr. President, to extend the Patriot Act till 2015, it would mean that for 4 more years, the federal government will continue to have unrestrained access to private information about Americans who have no connection to terrorism, with little to no accountability as to how these powers are used. And again, I want to go back to this. We all agree the intelligence community needs effective tools to combat terrorism. But we must provide those tools in a way that protects the constitutional freedoms of our people and lives up to the standard of transparency that democracy demands. The three controversial provisions that I've mentioned can be much better balanced to protect our people. Yet, it seems to me that many of our colleagues oppose any changes, and by making the Patriot Act provisions I've outlined permanent, we would be in effect preventing debate on them ever again. To travel that path would be to threaten constitutional and civil liberties that we hold dear in this country. That's not the right path. Mr. President, let me be clear. I do not oppose the reauthorization of these three provisions of the Patriot Act, but I do aim to bring forward some common-sense reforms that will allow us to strike an important balance between keeping our nation safe on the one hand while also protecting privacy and civil liberties. And toward that goal, I've worked side by side with my colleagues in coming up with common-sense fixes that could receive bipartisan support. One example, Senator Wyden from Oregon has filed an amendment which I've co-sponsored that would require that the Department of Justice disclose to Congress the official legal interpretation of the provisions of the Patriot Act. While I believe that our intelligence practices should be kept secret, I do not believe that the government's official interpretation of these laws should be kept secret. I've also filed my own amendments to address some of the problems I see with the three expiring provisions. The first amendment I've filed is bipartisan with Senator Paul of Kentucky, who's on the floor, and Senator Wyden, who's joined us as well. Our amendment would modify the roving wiretap authority under Section 206 of the Patriot Act. Specifically, our bipartisan amendment will require intelligence agencies to identify either the target or the place to be wiretapped. They currently do not have to do so. And I believe that when seeking to collect intelligence, law enforcement should at least have to identify who is being targeted. I've also filed an amendment to address the so-called lone wolf provision, which currently allows the government to conduct wiretap surveillance on individuals even when that person has no connection to a government or a terrorist organization. This amendment would simply require that should the intelligence community use the lone wolf provision, that Congress simply be notified. Again, a safeguard that is not in place as we stand here today. Without safeguards like that, how do we in this body conduct our constitutional duties of oversight? Finally, I was joined by Senator Wyden in filing an amendment designed to narrow the scope of business record materials that can be collected under Section 215 of the Patriot Act. This amendment would still allow law enforcement to use the Patriot Act to obtain such records, but would require these entities to demonstrate that the records are in some way connected to terrorism or clandestine intelligence activities. Right now, Mr. President, law enforcement can currently obtain any kind of records. In fact, the Patriot Act's only limitation states that such information has to be related to any tangible thing. That's right. As long as these business records are related to any tangible thing, the U.S. government can require businesses to turn over information on all of their customers, whether or not there's any link to terrorism.
Would my colleague yield for a question very briefly?
Yes.
It seems to me that you have laid out the case for why there needs to be a thoughtful debate about the Patriot Act and what's necessary to strike this key balance between fighting terrorism ferociously and protecting our liberties. I'm interested in what my colleague thinks about the proposition of how you have a thoughtful debate on these issues when there is secret law, where, in effect, the interpretation of the law as it stands today is kept secret. So here we are, United States senators on the floor, and we've had colleagues of both political parties wanting to participate in this. Certainly, if you're an American, you're in Oregon or Colorado, you're listening in, you want to be part of this discussion, but yet the executive branch keeps secret how they are interpreting the law. What's your sense about how we have a thoughtful debate if that continues?
The senator from Oregon's put his finger on why this is so important, not only have the debate here on the floor and not rush these provisions to the House because of a deadline that I think we could push back. We could, as you know, extend the Patriot Act in its present form for a number of other days or a number of weeks in order to get this right. But the senator from Oregon makes the powerful point that the law shouldn't be classified as far as its interpretation goes. Of course, we can protect sources and methods and operations, as we well should. Both of us serve on the Intelligence Committee. We're privy to some information that should be kept classified, but we've come to the floor to make this case because of what we've learned on the Intelligence Committee. I thank the Senator for his question. I look forward to his comments in a few minutes. And the Senator from Oregon, in effect, points out that these are just a few of the reform ideas that we could debate. But without further debate on any of these issues, this or any other administration can abuse the Patriot Act and could actually deny us as members of Congress, whether in this Congress or future Congresses, the opportunity to fulfill our oversight responsibilities on behalf of the American people. Mr. President, when I voted against the original passage of the Patriot Act in 2001, and I plan to vote against the reauthorization of these expiring provisions this week, unless we implement some reforms that will sensibly restrain these overly broad provisions. Simply put, again, to make the point that the Senator from Oregon made so importantly, I believe that Congress is granting powers to the executive branch that lead to abuse and, frankly, shield the executive branch from accountability. There have been 10 years since we first passed this law, and there's been very little opportunity to improve the law. And I just resist this rush to, again, rubber stamp policies that threaten the very liberty that we hold dear. I recently supported short-term extensions of the expiring provisions before us as a bridge to take time and debate and amend the Patriot Act and its controversial provisions. But we were notified, unfortunately, just a few days ago that we'd be voting on a 4-year extension of these expiring provisions, and that's just not the way to ensure that Americans, that we're diligently considering these important public decisions. In Federalist 51, James Madison, who we venerate, who was the author of many of the documents that structure and way in which we organize and operate our democracy, he wrote, quote, "In framing a government which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed, and in the next place, oblige it to control itself." The bill before us does not live up to that standard, and I believe it seriously risks the constitutional freedoms of our people. We need to strike a better balance between giving our national security and law enforcement officials the tools necessary to keep us safe while not damaging the very Constitution we have sworn to support and defend. By passing an unamended reauthorization, we are assuring that Americans will live with the status quo for 4 more long years. And I believe this bill may well be a lost opportunity to improve the balance between our security and our civil liberties. That's not the result that our founding fathers envisioned, and it's not a result that our constituents want. And for these reasons, if the Patriot Act provisions are not amended, I plan to vote no on the motion to invoke cloture and on passage of S. 1038. Before I yield the floor, Mr. President, I want to make one last historical reference. Ben Franklin, one of our founding fathers, said compellingly and presciently, he said, "A society that would sacrifice essential liberties for short-term security deserves neither." I think that's the question before us. There's a way forward. There's a way to keep the Patriot Act in place to protect our national security, but also to protect our essential liberties. But in order to do that, we have to have a chance to debate and pass these important amendments. Mr. President, I yield the floor.
Mr. President, before my colleague leaves the chamber, I just want to tell him what a welcome addition he's been to the Intelligence Committee. I've served on that committee for 10 years. We've had excellent chairs, first Senator Roberts, then Senator Rockefeller, Senator Feinstein. So we continue to try to look for bipartisan support for trying to strike that balance between collective security and individual liberty. And I'm struck both by the clarity of your statement and the fact that those who are going to vote on these amendments and the American people who are listening in tonight really ought to be able to get in a straightforward, easy-to-access fashion how the executive branch is currently interpreting the Patriot Act. I mean, the fact of the matter is law professors give assignments to their students to write analyses of the Patriot Act. The Congressional Research Service actually has an analysis out, but it's not possible to get the official interpretation of how the U.S. government frames this law for the operations that are so essential for our country. So you have laid it out very well, and it is a pleasure to serve with you on the Intelligence Committee. Mr. President, let me try to sum up what this issue has come down to me. These are dangerous times. If you go into the Intelligence Committee several times a week, as Senator Udall and I do, you come away with the indisputable judgment that there are threats to the well-being of this country, that there are people who do not wish our citizens well. So in these dangerous times, the sources and methods of our anti-terror operations absolutely must be kept secret. That is fundamental to the work of the intelligence community, keeping the sources and methods of those who serve us so gallantly secret and ensure that they are as safe as possible. But while we protect those sources and methods, the laws that authorize them should not be kept secret from the American people. And that, Mr. President, is what this is all about, is whether or not the laws that authorize the operations that are so essential, that have been passed by the Congress, that their interpretation should be kept secret from the American people. I call it secret law, Mr. President. And I want to say to this body, yes, we need secret operations, but secret law is bad for our democracy. It will undermine the confidence that the American people have in our intelligence operations. And you might recall it was only a few years ago, during the Bush administration, where they secretly reinterpreted the warrantless wiretapping statute to say that it was possible to wiretap our people without a warrant. When it came out, it took years to sort that out, the executive branch and the Congress working together. I don't want to see that happen again, Mr. President. So that is why I have joined Senator Udall in these amendments, hope that we can get bipartisan support for what we're trying to do, and especially ensure that the official interpretation of the Patriot Act and important intelligence statutes, that is made public to the American people, and I think it can be done in a way without jeopardizing our sources and methods. Now, one of the reasons Senator Udall and I and others feel so strongly about this, Mr. President, is this is a time, and I think Senator Udall touched on this, when Congress finally should say we're not just going to keep kicking the can down the road. That's what's been done again and again over the last decade. Patriot Act was passed a decade ago during a period of understandable fear, having suffered in our nation the greatest terrorist attack in our history. So the Patriot Act was born out of those great fears, and it seems to me now is the time to revisit it and ensure that a better job is done of striking that balance between fighting terror and protecting individual liberty. Unfortunately, every time over the last decade there's been an effort to do just that, to revisit this and strike a better balance, we've had the same, pattern. We've said we've just got to get it done quickly, and we really don't have any time to consider, for example, the thoughtful ideas that Senator Udall has mentioned. And I just don't think that it is time now to once again put a real debate on the Patriot Act off for yet another always distant day. Now, there is an irony about what this is all about, and that is that senators are going to want to consider the amendments of Senator Udall. I see, I believe Senator Paul is here. There are others that care strongly about this. It is awfully hard to have a thoughtful debate on these specific amendments, whether it's the Leahy Amendment, the Paul Amendment, the Udall Amendment, the ones we have together, if in fact you can't figure out how the executive branch is interpreting the law. An open and informed debate on the Patriot Act requires that we get beyond the fact that the executive branch relies on these secret legal interpretations to support their work, and members of the United States Senate try to figure out what those interpretations are. Now, here are the rules. If a United States senator wants to go to the Intelligence Committee, and I think Senator Udall touched on this, the United States senator can go there and get a briefing. Many members of Congress, however, don't have staff members who are cleared for those kinds of briefings. Under Senate rules, it's not possible for senators to come down here and discuss what they may have picked up in one of those classified, briefings. And I just don't think, with respect to the legal interpretation, that's what the American people believe we ought to be doing here. The American people want secret operations protected. They understand what sources and methods are all about, and that we have to have secrecy, for example, for those in the intelligence community to get the information we need about sleeper cells and terrorist groups and the threats that we learn about in the Intelligence Committee. But that is very different than keeping these legal interpretations secret. And in my view, the current situation is simply unacceptable. The American people recognize that their government can better protect national security if it's sometimes allowed to operate in secrecy, and they certainly don't expect the administration, the executive branch, to publish every detail about how intelligence is collected. Certainly, Americans never expected George Washington to tell them about his plans for observing troop movements at Yorktown. But Americans have always expected their government to operate within the boundaries of publicly understood law. And as voters, they certainly have a right to know how the law is being interpreted so that the American people can ratify or reject decisions made on their behalf. To put it another way, Americans know that their government will sometimes conduct secret operations, but they don't believe the government ought to be writing secret law. And the reason why we have felt so strongly about this issue of secret law is that it violates the trust that Americans place in their government, and it undermines public confidence in government institutions and agencies, making it harder for them to operate effectively. I was on the Intelligence Committee, Mr. President. I think this was a little before Senator Udall joined us, when Americans were pretty much stunned to learn that the Bush administration had been secretly claiming for years that warrantless wiretapping was legal. My own view was that that disclosure significantly undermined the public's trust in the Department of Justice and our national intelligence agencies. Our phones were ringing off the hook for days when the American people learned about it, and the Congress and the executive branch then had to, in effect, retrench and figure out how to sort it out. I certainly believe that the public is going to be surprised again when they learn about some of the interpretations of the Patriot Act. And government officials cannot hope to indefinitely prevent the American people from learning the truth. This is going to come out, colleagues. It is going to come out at some point, just as it came out during the Bush administration about warrantless wiretapping. It's going to come out, and it is not going to be helpful to the kind of dialogue we want to have with the American people, an open and honest dialogue with the American people, to just continue this practice of secret law. Now, the reason that I'm offering or seeking to offer this amendment with Senator Udall and Senator Merkley and colleagues with respect to changing the practice of secret law is we have raised this issue numerous times. We've raised it on the Senate floor. We have raised it in correspondence, in meetings with senior administration officials. I've been joined in the past by other senators. We've talked about it with respect to the problem in the news media. But the problem persists, and the gap between the public's understanding of the Patriot Act and the government's secret interpretation of the Patriot Act remains today. And once information has been labeled secret, there is a strong bureaucratic tendency, it almost gets in the bureaucratic chromosomes, to keep it secret and not revisit the original decision. So what Senator Udall and I and colleagues seek to do is correct this problem. We seek to offer an amendment that states that it is entirely appropriate for particular intelligence collection techniques to be kept secret, but that the laws that authorize these techniques should not be kept secret and should instead be transparent to the public. We seek to offer an amendment that states that U.S. government officials should not secretly reinterpret public laws and statutes in a manner that is inconsistent with the public's understanding of these laws or describe the execution of these laws in a way that misinforms or misleads the public. So under this proposal, the Attorney General and Director of National Intelligence would, and we note this, provide a classified report to the Congressional Intelligence Committees. It makes it clear that intelligence collection continues to go forward, and our amendment would simply require the Attorney General to publicly lay out the legal basis for the intelligence activities described in the report. The amendment specifically directs the Attorney General not to describe specific collection programs or activities, but simply to fully describe the legal interpretations and analyses necessary to understand the government's official interpretation of the law. Let me close, Mr. President. I see colleagues waiting to speak, that we can have honest and legitimate disagreements about exactly how broad intelligence collection authorities ought to be, and members of the public do not expect to know all of the details about how those authorities are used. But I would hope that each senator would agree that the law itself should not be kept secret, and that the government should always be open and honest with the American people about what the law means. All that Senator Udall and I seek to do, and colleagues, is to restore some of that openness and honesty in an area where it is now needed, and I hope that colleagues here on the floor of the Senate and in the Obama administration will join in that effort. Mr. President, with that, I yield the floor. President, I would suggest the absence of a quorum.
Mr. Akaka.
call be dispensed with.
Without objection.
Mr. President, on Thursday, in a speech on the Middle East, President Obama said, while we believe the borders of Israel and Palestine should be based on the 1967 lines with mutually agreed swaps so that secure and recognized borders are established for both states. While the President has since sought to revise or clarify his remarks, it is valuable to remind ourselves what a retreat to the pre-1967 boundaries would mean for the security of Israel. After Israel declared independence in 1948, it was invaded by 5 neighboring armies, and an armistice line was subsequently established in 1949. This line is known as the Green Line, and while some refer to it as a border, it was never officially recognized as an international border. If Israel was forced to retreat to the Green Line, its pre-1967 boundary, Israel would be only 9 miles wide at its narrowest point. Such close borders are untenable today and would subject Israel's population to great and grave danger. Following the Six-Day War, UN Security Council Resolution 242 affirmed Israel's right to secure and recognized borders. As Robert Satloff of the Washington Institute for Near East Policy points out, calls for Israel to withdraw to those secure and recognized borders have never been interpreted as being synonymous with the pre-1967 boundaries. A quick look at a map of Israel will explain why these boundaries cannot be secure. Prime Minister Netanyahu today in a joint session of Congress reminded us that, quote, Israel needs unique security arrangements because of its unique size. 2/3 of Israel's population and infrastructure lie within a 60-mile strip along the Mediterranean coastline. Tel Aviv would only be 11 miles away from a Palestinian state with its border as the Green Line, and the Ben Gurion Airport, Israel's largest and busiest, would be a mere 4 miles away. It would only take one rocket fired at Ben Gurion for the entire airport to shut down, isolating Israel from the rest of the world. With the Green Line as its border, the dangers to Israel come not only because of the short distances between major Israeli cities and the Palestinian state, but also from the geography of the land. The 60-mile strip along Israel's coastline lies below the hilly heights of the West Bank. With control of that high terrain, terrorists could easily target and terrorize much of Israel's population, just as they have from Gaza, but with even more deadly accuracy. When Israel unilaterally withdrew from Gaza in 2005, Israel's leaders had hoped that the Palestinians would demonstrate they could live peacefully with Israel. Instead, Hamas assumed power, and Israelis living in the southern part of Israel have had thousands of rockets and mortar attacks directed at them. So far this year, more than 300 rockets and mortars have been fired from Gaza, terrorizing countless families in Israel. The threats to Israel from a Palestinian state with its borders as the Green Line are clearly understood in this context, especially since the Palestinian Authority President, Abbas, his Fatah party, has inked an accord with Hamas to form a unity government earlier this month. Although welcomed by President Abbas, Hamas still calls for the destruction of the State of Israel. The United States designated Hamas as a terrorist organization in 1997. It has killed more than 500 innocent civilians, including dozens of Americans. The United States does not negotiate with terrorists, and we should not expect or ask Israel to do so either. Instead of calling for negotiations based on boundaries that leave Israel vulnerable to attack, the President should have insisted that the Palestinians prove that they are ready to be responsible and peaceful neighbors. As Prime Minister Netanyahu said, the Palestinian Authority must choose either peace with Israel or peace with Hamas. There is no possibility for peace with both. Israel's security must come first. Any effort to force Israel to withdraw to its pre-1967 boundaries, the 1949 armistice line, would undermine Israel's security and threaten the future of any peace talk. In 2004, the Senate overwhelmingly passed Senate Resolution 393, which endorsed U.S. policy for a Middle East peace process. In particular, the Senate supported a statement that said, in light of the realities on the ground, including already existing major Israeli population centers, it is unrealistic to expect that the outcome of final status negotiations will be a full and complete return to the armistice lines of 1949. I believe it's important for the United States to again oppose any plan to force Israel to withdraw to those 49 boundaries. Borders between Israel and a Palestinian state should be decided only by Israel and Palestinian leaders through direct negotiations. Borders should not be a precondition set for negotiations by the President of the United States or anyone else. As Prime Minister Netanyahu said today, peace cannot be imposed. Since recognizing Israel 11 minutes after its founding in 1948, our two countries have worked side by side to advance democracy and peace and stability. Israel is our staunchest ally in a volatile part of the world. We cannot now turn our back on Israel by forcing it to take a position in negotiations that would endanger its very existence. I oppose any plan or effort to force Israel back to those 1949 armistice lines and encourage my colleagues to work to see that that is not the case. I ask my colleagues to support that position as well. Mr. President, I notice the absence of a quorum. I yield back the floor.
The clerk will call the roll.
Mr. Akaka.
The Majority Leader.
Is the Senate in a quorum call?
Yes,
I would ask consent that that be vitiated.
without objection.
Mr. President, we've been working for, and I've been working on it for a lot longer than several days, but several days publicly on process to move forward with the Patriot Act. We have worked over the last several days to work something out that is, I think, an excellent compromise. Is this bill something that everybody in the Senate likes or everybody in the House likes? The answer is no. But we all know how important it is that we continue this legislation. So Senator McConnell and I and Speaker Boehner have agreed on a way to move forward on this. The alternative is to have a long-term extension of this that the House would send us, and I think that wouldn't be to anyone's benefit. So we're moving forward on this. I've tried to do it with the bill that we invoked cloture on yesterday. I've had many conversations with Senator Paul and others, but principally him, and tried to come up with a process to allow Senator Paul to offer amendments and others to offer amendments. It's not just him. I've been unsuccessful. Now, I understand Senator Paul's exasperation because this is something that is extremely important to him, and there was every desire from my perspective, and I think this body, to have a full, complete debate on the Patriot Act. But the Senate doesn't always work that way. And there have been a lot of things that have gotten in the way of this, and the time is suddenly upon us. Mr. President, we have to complete this legislation by midnight on Thursday. We cannot let this expire. We cannot let the Patriot Act expire. I have a responsibility to try to get this bill done as soon as possible, in spite of the fact that some of my senators and some Republican senators would rather I did it some other way, at some other time. But I don't have that I can't do that. I have to get this done. We know since bin Laden was killed that there's been a lot of information discovered from him that he did. And the one thing that's very clear, that he had instructed all of his lieutenants to focus all their attention on the United States and its assets. So we can't let this expire, and I'm going to do everything I can to make sure that this does not happen. Senator Paul and I have tried to work out something. He feels strongly about at least 3 of his amendments. And I say, even though he and I disagree on a number of things politically, I have found his time here in the Senate, as it relates to me, to be one of, he's a very pleasant man with strong feelings. And I have only the highest regard for him. And I'm sorry that I can't make this system we have here in the Senate more in keeping with his desires to get things done. But if he will learn over the years that it's always difficult to get what you want in the Senate. It doesn't mean you won't get it, but sometimes you have to wait and get it done at some subsequent time. So Senator Paul has been very upfront with me. He's never hidden a punch, or he said that I feel strongly about a number of these amendments, and I'm not going to agree to let this go forward unless I have these amendments. And he's been very reasonable. He's brought his number down from 11 to 3 or 4, and I appreciate that. But, Mr. President, the time has come for me to take some action. Again, I repeat, I don't have the luxury of waiting for a better time. I really would like to be able to allow the Center from Kentucky to give a few of his stem-winding speeches. He does a very, very good job of presenting himself. But in order to expedite what I think is so important, to move the country's intelligence operations, to make them continue, I should say, I'm going to move to table the pending motion to proceed to S. 1038. Following that vote, I'll ask the Chair to lay before the Senate a message received from the House earlier today. I will then move to concur with an amendment, which will be the extension of the Patriot Act, and I'll file cloture on that motion. Ask for the yeas and nays.
The question is on the motion to table. Is there a sufficient second? At this moment, there is a sufficient second. The clerk will call the roll.
Mr. Akaka, Mr. Alexander, Ms. Ayotte, Mr. Barrasso, Mr. Baucus, Mr. Bekich, Mr. Bennett, Mr. Bingaman, Mr. Blumenthal, Mr. Blunt, Mr. Bozeman, Mrs. Boxer, Mr. Brown in Massachusetts, Mr. Brown of Ohio, Mr. Burr, Ms. Cantwell, Mr. Cardin, Mr. Carper, Mr. Casey, Mr. Chambliss, Mr. Coates, Mr. Coburn, Mr. Cochran, Ms. Collins, Mr. Conrad, Mr. Coons, Mr. Corker,
He's sticking to his guns, which means we would vote on the motion to proceed at what order of midnight.
Mr. Cornyn,
Then you'd by
Mr. Crapo,
we'd have another 30 hours on the bill.
Mr. DeMint,
To shortcut that process.
Mr. Durbin,
Message today, which means
Mr. Enzi,
we've got our Senate bill.
Mrs. Feinstein,
that we sent over there.
Mr. Franken, Mrs. Gillibrand,
The message from the House is
Mr. Graham, Mr. Grassley, Mrs. Hagan, Mr. Harkins, Mr. Hatch, Mr. Heller, Mr. Hoven, Mrs. Hutcherson, Mr. Inhofe,
well, we're not done.
Mr. No Way,
This is
Mr. Isaacson,
its own rights by having that.
Mr. Johans, Mr. Johnson of Wisconsin, Mr. Johnson of South Dakota, Mr. Kerry, Mr. Kirk, Ms. Klobuchar, Mr. Cole, Mr. Kyle, Ms. Landrieu, Mr. Lautenberg, Mr. Leahy, Mr. Lee, Mr. Levin, Mr. Lieberman, Mr. Lugar, Mr. Manchin, Mr. McCain, Mrs. McCaskill, Mr. McConnell, Mr. Menendez, Mr. Merkley, Ms. Mikulski, Mr. Moran, Ms. Murkowski, Mrs. Murray, Mr. Nelson, Nebraska, Mr. Nelson of Florida, Mr. Paul, Mr. Portman, Mr. Pryor, Mr. Reed of Rhode Island, Mr. Reed of Nevada, Mr. Risch, Mr. Roberts, Mr. Rockefeller, Mr. Rubio, Mr. Sanders, Mr. Schumer, Mr. Sessions, Mrs. Shaheen, Ms. Snow.
This has become
Ms. Stabenow.
more common than not. When they come,
Mr. Tester.
when they come and sit, and just, well, that's not
Mr. Thune.
happens.
Mr. Toomey. Mr. Udall of Colorado.
You know, ordinary.
Mr. Udall of New Mexico. Mr. Vitter. Mr. Warner. Mr. Webb. Mr. Whitehouse. Mr. Wicker. Mr. Wyden. Senators voting in the affirmative: Baucus, Conrad, Gillibrand, Isaacson, McConnell, Murray, Nelson of Florida, Reed of Rhode Island, Rubio, and Tester. No senator voted in the negative. Mr. Reed of Nevada, aye. Mr. Johans, aye. Mr. Barrasso, aye. Mr. Webb? Aye. Mr. Cochran? Aye.
What's the 30 hours?
Ms. Ayotte? Aye. Mr. No Way? Aye.
We hardly ever use 30 hours when we do it. It's like this, if a senator insists that you use up all the time, you have to use up all the
Mr.
time.
Udall, New Mexico? No.
And he did, he did allow them to count.
Mr. Brown of Ohio? Aye. Mr. Warner? Aye. Mr. Blumenthal? Mr. Blumenthal? Aye. Mr. Brown of Massachusetts? Aye. Mr. Merkley? Mr. Merkley? Aye. Mr. Merkley? No. Mr. McCain? Aye. Mr. Tester? No. Mr. Cornyn? Aye. Mr. Sessions? Aye. Mr. Corker? Aye. Mr. Graham? Aye. Mr. Johnson? Mr. Johnson of Wisconsin? Aye. Mr. Grassley? Aye. Mr. Lugar? Aye. Ms. Collins? Ms. Collins? Aye. Mr. Kyle? Aye. Mr. Chambliss? Mr. Chambliss? Aye. Mr. Hoven? Aye. Mr. Shelby? Aye. Mr. Wyden? No. Mr. Coates? Mr. Coates? Aye. Mr. Nelson? Mr. Nelson, Nebraska? Aye. Mr. Lautenberg, aye. Mr. Bennett, aye. Ms. Stabenow, aye. Mr. Cole, aye. Mr. Alexander, aye. Mr. Kirk, aye. Ms. Mikulski. Ms. Mikulski, aye. Mr. Hatch. Mr. Hatch, aye. Mr. Menendez. Mr. Menendez, aye. Mr. Wicker, aye. Mr. Dement, aye. Mr. Toomey. Mr. Toomey, aye. Mr. Heller, aye. Mr. Coburn, aye. Mr. Durbin. Mr. Durbin, aye. Mr. Bingaman. Mr. Bingaman, aye.